Sanibonani bakwethu. Ninjani kodwa? Right. Thank you very much, Anastasia. You got the name right today. Congratulations. Like Anastasia said, my name is Mziwodumo Rubushe. I'm from the Competition Commission, South Africa. I'm not an entrepreneur, obviously. The Competition Commission basically is a regulator established in terms of legislation, the Competition Act in this particular instance. Just by way of background, ladies and gentlemen, why do we have an institution like the Competition Commission? We have the Commission because, unfortunately, given our historical baggage, in South Africa, where the economy was very highly concentrated and concentrated in a very few hands. So the democratic government then, established the Competition Commission, whose purpose really is to regulate market conduct, in South Africa. So we are established in terms of legislation, and then our mandate is to promote competition in the South African economy. And this competition, ladies and gentlemen, is not Nastasia's competition, beauty pageants. It's basically competition between businesses. So we are here today to share with you how we, as the Competition Commission, basically create conditions for small businesses to be able to compete in the South African economy. So basically, that's in a nutshell, who we are and how we came about and why we are here today. So the areas that we're going to be touching on, we're going to be touching on basically, like I indicated, the objectives of our legislation. That is what it intends to achieve. And then secondly, we have what we call prohibited practices in terms of our legislation. What are those? And then we're going to touch on how our major regulation function benefits SMMEs. And also, one of the functions that we do is that of market inquiries. And what are we currently doing, in the SMME space. Is there anyone, by the way, who have ever heard in the hall of this institution called Competition Commission? What kind of an animal or a beast is this? And what is it there for, what it's doing? I saw a hand there. What do you know about us, sir?
To actually declare, thank you. Part of the tendering process, I was saying that requires one to declare if you're submitting your proposal or your tender for whatever services or goods that the entity might be looking for. You need to state that you are submitting that particular proposal independently without colluding with other suppliers or service providers in the market.
Yeah, the SPT9.
Yes, that's correct.
The SPT9, yes. I actually drew up that SPT9. I drafted it myself. Thank you very much. Anybody else? Yes, sir? Yeah, very good. He's indicating that he's aware of the important role that the Commission plays in the mergers and acquisition space. And he says that the intention is to make sure that small businesses are not, without, the unintended consequence, of being abused by the bigger players, and is absolutely correct. Thank you very much. I'm glad that, we have people, within the hall that are actually familiar with the work that we actually do. It means that, at least the work that we do is able to reach nationally, and people appreciate what we do, which is very encouraging. Here we're just touching on, ladies and gentlemen, this is just a reflection that you see there in terms of who we are as competition authorities. Basically, competition authorities consists of three distinct institutions. Firstly, is us as the Competition Commission. We are the investigator and prosecutor of the competition authorities. And then we've got two independent institutions, which is the tribunal, as well as the Competitions Appeal Court. So the distinction basically between the Commission and these two other institutions is the fact that whilst we as the Commission were the prosecutor, the tribunal, as well as the Competition Appeal Court, are the adjudicating bodies. What that means is that those two institutions, they review the decisions of the competition authority. So any party that is not happy with our decision as the competition authorities, they have recourse to the tribunal as well as to the Competitions Appeal Court. Now, ladies and gentlemen, I did allude to the fact that, obviously there were objectives for establishing our authorities, and therefore there was a legislation that governs the Commission, and therefore it had specific objectives that are prescribed by the legislation, and one of those is that of ensuring that SMMEs have an opportunity, to participate in the economy. Therefore, our responsibility as the Commission is to make sure that we create conditions in which SMMEs actually compete. Like my friend here has indicated, one of the functions that we do as the Commission is that of merger regulation, meaning therefore that a company that is buying another company in South Africa, in simple terms, they have an obligation to notify us of their intention to acquire another company, provided they meet the necessary threshold. And therefore, as the Commission, we've got powers to approve these measures, to approve them with conditions. We also have powers to prohibit these measures. When we prohibit, it means we are saying that the measure should not proceed. It should not be consummated. One of those that we did, which was an SMME one, was when Pick n Pay wanted to buy fruit and veg in South Africa. So what happened is that the Pick n Pay group, they did the research after they've noticed that their fruit and veg departments within the Pick n Pay group were not making much money compared to other products. So they wanted to establish what are the reasons behind this. And they found out that what customers do is that they buy in the supermarket bulk products. However, when it came to fruit and veg, they push their trolleys out and they go to fruit and veg on the other side of the road, And that's why then their sales in their fruit and veg department were not increasing. In fact, they were declining. That's what they wanted to basically establish. So then Pick n Pay took a decision that in the circumstances, what then they will do is that they must simply buy fruit and veg, such that they own fruit and veg. Now, from a competition law point of view, our responsibility then in such circumstances is to evaluate the measure, and the test for us is whether the measure will basically lessen competition. And then that's what basically we investigate. And then the outcome of our investigation in that instance was that if we allow then Pick n Pay to buy fruit and veg, it will eliminate what we called an effective competitor in the fruit and veg market. And our concern also was that once that measure is consummated, the prices of fruit and veg will actually increase, because Pick n Pay will no longer have the constraint of fruit and veg outside. that provided that competitive constraint. So it will be completely eliminated. So in that instance, then we prohibited the merger, meaning therefore that we blocked the merger did not proceed. What is interesting as an outcome of that decision is the growth of fruit and veg. I mean, the ladies, I'm sure they will be aware of this. Fruit and veg grew from being that small business on the other side of the road to now what is called a fruit lovers market. And it is huge. What that means, therefore, that it was able to grow as a consequence of customers buying, I mean, their product, and therefore, that business was able then to grow into what is now called fruit lovers market. And they sell even more stuff now. They have gone beyond just selling fruit and veg. And the prices are still competitive because, I mean, as a commission, I mean, we blocked that measure. And then our view was that had we approved that measure, chances are, I mean, that business would not have been able to grow to the extent that it has grown, and the pricing would have been totally different, because you would have eliminated an effective competitor in the market, in the fruit and veg market specifically. So those are some of the things that functions that we perform as a commission that benefit you as a consumer. So these are some of the services that we actually render, ladies and gentlemen. Advisory opinion. So in advisory opinion, if as an SMME, for an example, you identify a conduct by a bigger player, and then you are uncertain in terms of whether it will result, it may be an anti-competitive conduct or not, you can request an advisory opinion from us, we will provide it. Even yourself, as an SMME, if you're uncertain about the conduct that you're about to embark on, whether it may be a contravention of our legislation, I mean, you are free to request an advisory opinion from the competition authorities. And that advisory opinion will actually be provided. So those are some of the services that we provide. Now, we mostly get asked, people want to know, okay, what is it that is not allowed, and then what is it that is allowed? You know, what we call, refer to as prohibited practices. So basically, that's the provisions of Chapter 2 of our legislation, and then that's what we will be touching on now. So we have basically two groups of prohibited practices, what we call horizontal restrictive practices and vertical restrictive practices. Now, when it comes to horizontal restrictive practices, this is conduct between competitors in the market, ladies and gentlemen, meaning, therefore, that it's an act that is anti-competitive conducted by, for an example, Pick n Pay and ShopRite Checkers. They are supposed to be competing in the market. So they are not allowed to have agreements that have the effect of lessening competition in the market. So it's specific reference in this instance, that's Section 4.1 of our legislation, A. So we also have then what is referred to as per se prohibited practices. Now, this is conduct, ladies and gentlemen, that you will not be allowed any defenses, meaning, therefore, in simple terms, you will not be allowed to justify the conduct. You will be prosecuted by the competition authorities straight away. You will not be allowed to justify their conduct. And that conduct is what we refer to as price fixing, market allocation, as well as collusive tendering. Those are referred to as per se prohibited practices, meaning, therefore, that a firm or a company that engages in those conduct will not be afforded an opportunity to justify the conduct. So most of the cases, I mean, that are popular, I mean, within the public space are those that are in the per se prohibited, that is our cartel prosecutions, price fixing, market allocation, as well as collusive tendering. Now, people may recall that we investigated the construction sector. Any of us remember that? We investigated the infrastructure build program that was done in preparation for the World Cup, including your FIFA 2010 stadiums. And here in KwaZulu-Natal, the Moses Mabhida Stadium was one of those that were affected, actually. And when we say they were affected, what we were investigating basically was a cartel conduct in the form of collusive tendering. So what happened is, as well as, market allocation. So what happened when it came to the building of the stadiums, for an example, those companies, they simply came together instead of competing to build those stadiums. They came together and simply agreed amongst themselves which company will build which stadium. Now, where you don't have competition, ladies and gentlemen, you must know once companies are not competing amongst themselves, then what you are likely then to have is higher prices. And in this case, again, of these stadiums, what then happened is that the prices, therefore, to construct these stadiums became extremely expensive as a consequence of these companies actually not competing in the bidding process to build these stadiums, but they simply came together and allocated these stadiums amongst themselves. Allocating meaning they agreed amongst themselves which company will build Moses Mabhida, which one will build Nelson Mandela in the Eastern Cape, Peter Makaba in Limpopo, and the Greenpoint Stadium in the Western Cape. So the implication for you as a consumer is that the state paid far more than it ought to have paid to build those particular stadiums. And remember, when the state pays, it's your taxpayers' money, which is you and I that have to pay. So that's how basically it affects you and I from a consumer point of view. Now, the other restrictive practices is the vertical agreements. Now, these are agreements between your retailers and your manufacturers. Again, here, companies in that relationship are not allowed to conclude agreements that lessen competition in the market. Also, in Section 5 of the Act, we have what we call a per se prohibited practice, which is a minimum resale price maintenance. Again, what's the difference is that when it regards to that one, you are not allowed any justifications. You will not be allowed to justify the conduct from our side as the competition. If a company engages in minimum resale price maintenance, it will be prosecuted by the competition authorities. So in the past, we have prosecuted these car manufacturers for engaging in that conduct. So when we prosecute in our case, we don't, we basically impose administrative penalties, meaning therefore that the companies, for contravening these conducts, we impose administrative penalties. I did indicate that SMMEs, basically the big function that we do is that of mergers and acquisitions. And one of the major considerations that we have to take into account when we investigate a merger, that is the acquisition of one company by another, is to make sure that that merger does not affect SMMEs negatively. That's one of the considerations that we have a legal obligation to consider before we approve a merger. So that's why we are reflecting basically this. So what do we do in circumstances where a merger can negatively affect an SMME? In most instances, then what we do is that we attach conditions to that particular measure. So that's why we are reflecting there that, since 2010, at least 15 transactions were approved with conditions that protect SMMEs. So ours is to protect SMMEs so that we create conditions wherein SMMEs can actually perform without being abused by big companies. Another case that we had, ladies and gentlemen, probably we are also aware of this. There was an American company called Walmart that came to South Africa to buy the Massmart Group. Your Massmart Group is your Grey Games and then your Macros and all of those companies. So they came into South Africa to buy Massmart Group. Again, as a commission, our responsibility was to investigate, the effects of this measure prior to us then taking a decision whether to approve this measure. And one of the decisions then that were taken with regards to the Massmart measure was to establish a fund, ladies and gentlemen, that will then protect South African suppliers against this giant company that was coming to South Africa. How was this done? A supplier development fund was established, and the amount set aside was 240 million rand. And that was a condition that was attached to approving that measure. So why was that fund established, ladies and gentlemen? Again, it was to protect South African suppliers, and also it was to create a fund that they can access such that they are able to develop and grow and be able to supply products of quality to the Walmart Group, that is the acquiring firm. So that's why then that fund was established. And it has run very well to date. There is a gentleman in the Free State, who now owns a milling factory. A black guy who's 29 years old, a very young chap. He now owns a milling factory, and then he utilized basically funds, from this particular fund. And remember, ladies and gentlemen, that this fund was established against the measure that was in that market, okay, the food and agro market. And therefore, it was established to be used by players within, the suppliers within that space. And therefore, since 2012, as the Commission, we imposed conditions again on 25 property measures, again, whose objective was to protect SMMEs from what is called exclusive agreements. Those are some of the measures that we have taken as a Commission to protect you as an SMME. Now, one of the reasons, Natasha, that we are engaging with SMMEs nationally is to make sure that SMMEs are able to participate in our processes. How? They must be able to identify and see when a conduct by bigger players actually is anti-competitive and can negatively affect them. And they are able then to participate in our processes by firstly lodging complaints and therefore participating in tribunal hearings when they are affected. It's just like your human rights, Natasha. We can have all the nice constitution that we have in South Africa, but if the citizens of the country actually do not even know what those rights are, and they don't exercise them, they are dead fish, basically, in the water. Similarly, if SMMEs basically are not aware that there is a legislation that protects them against abuse from bigger companies and their responsibilities, then we will have a challenge. And one of the likely negative outcomes of that, you will have SMMEs that will be closing shop because of abuse by bigger players in circumstances where they ought not to have closed shop. So the Commission, like I indicated, is there to create conditions for SMMEs to compete and to protect them against what we call abuse of dominance by bigger players. So we are just reflecting here one of the cases that we have, a Sasol Nitro case that we also investigated and prosecuted as the competition authorities. And one of the outcomes of that case was that this big company, Sasol, settled with us as a Commission, meaning therefore that they came to negotiate with the Commission And then what we did then, we attached a condition that they must divest, some of their subsidiaries. Those are some of the powers that we have. So when we order a company to divest, we are instructing the company to sell some of its subsidiaries. And that's where opportunities actually arise for small players, to come in terms of buying some of these companies, and therefore creating conditions basically for new players to enter the market. That is, those that were outside to actually enter the market. So in this particular case, we ordered what we call a divestiture. And then another case that we had was a company called Nationwide Poles. This company was a small company in the Eastern Cape that basically was producing poles. However, Sasol was charging this company for its product that is called creosol. It's an oil basically that is designed to preserve the pole. But it was extremely expensive. And the company then reported the matter to us, and then it went to the tribunal. And then the tribunal did rule, that Sasol had basically engaged in price discrimination, meaning therefore that they have charged Nationwide Poles far higher prices compared to its competitors. And then that had an effect of that company not actually doing well. And the company, unfortunately, went under. So the company no longer exists. And it was there before, but the company then, as a consequence, it closed shop. So these things do happen. Okay. One of the powers that we have then, colleagues, is that of market inquiries. And currently we are undertaking an inquiry into the retail space. So we're just reflecting there who the panelists are. That inquiry is still running. And what are the terms of reference of this inquiry? The inquiry is looking at, for an example, ladies and gentlemen, what is the effect of the movement of malls into townships? What is the effect of that on South African businesses? Remember, before the opening up of the floodgates, as it were, there was your Babam Shongo, a general store in your township. There was your Babam Kize general store, in Umlazi, and so on and so on. And that was a phenomenon in all the townships. But that picture has completely changed now. There's malls in the township, and most of those businesses no longer exist. So the inquiry then is looking at that. And then the other issue then, that dynamic that has came, has been then the movement of foreign-owned businesses into the townships, from Pakistan and all these other places into the townships. How has that then also impacted on small business within the townships? So these are issues that the inquiry is looking at, and that inquiry is still ongoing. It's not yet complete. So, like I said, it is looking at the impact of the expansion of national supermarket chains on SMMEs in the townships. It's also looking at the impact of long-term lease agreements, competition between local and foreign national operated small and independent retailers. And it's also looking at regulations. What is the effect of regulations, bylaws of the municipalities, and also buyer groups? How do all of these affect you as SMMEs? That's what the inquiry that we are currently undertaking is looking at. Of course, ladies and gentlemen, this inquiry is informed by the number of complaints that the Competition Commission has been receiving over the years related to SMMEs. So a decision then was taken to go the inquiry route. And then lastly, I mean, our Act also provides for exemptions. So an exemption basically indicates that you will not be prosecuted for engaging in this particular conduct. So specifically here, there is a Section 10.3 provision in our legislation which simply provides that the Competition Commission may grant an exemption if the agreement or practice concerned contributes to promotion of the ability of small businesses or firms controlled or owned by historically disadvantaged persons to become competitive. So, again, the implication of this, ladies and gentlemen, simply means that as an SMME, our legislation grants you an opportunity that you may, if you are engaging in an act that may contravene the Competition Act, you may apply basically for an exemption. This also applies if you, as SMMEs, for example, you want to come together and export your products collectively, even though you are competitors, basically in the market. Again, our legislation provides that you can actually apply for an exemption to the Competition Commission for a certain period of time. It's not a blanket exemption. It has to be for a certain period of time, then that is granted. Again, the intention there is to make sure that SMMEs are able, I mean, to flourish and therefore trade and compete fairly without imposing unnecessary regulatory burdens. So the Act then protects SMMEs in that fashion. I hope, ladies and gentlemen, I was making sense, and therefore, you know, you could relate to the issues that I was raising. The danger with legal mandates is always being too technical, you know, and all of that. So I hope I broke it down in a simple language that you can actually understand and appreciate. Yeah, and yeah, Nastasia, I will be happy to also take questions from SMEs regarding everything that I have said, and so on. I will be happy to take questions.